Hello everyone, I'm Nazarat Fatima. Welcome to LiveLaw. You all are aware of the matter pertaining to the challenge to abrogation of Article 370, a step which was taken in the year 2019 on August 5. The batch of petitions challenging the abrogation of Article 370 is being heard in the Supreme Court presently, and the petitioner's side has already completed the arguments. Presently, the Solicitor General and the Attorney General are arguing on behalf of the Union Government, and the bench comprising CJI D.Y. Chandrachud, Justices S.K. Kaul, Sanjeev Khanna, B.R. Gawai and Suryakant are hearing the arguments raised by the respondents. Let's begin with what the Attorney General had to say while arguing in the case. The first limb of his argument was that impossibility cannot paralyze President's powers. Explaining the argument, the Attorney General said that the law does not compel one to do what one cannot perform. In this context, he stated that since the Constituent Assembly had already dissolved, the President could no longer be compelled to take its recommendation for the abrogation of Article 370 under Article 370, Clause 3. He asserted that the action of taking the Constituent Assembly's recommendation was impossible now because it could not have the effect of paralyzing the President's power. The Attorney General asserted that there was no mathematical formula to solve the international disturbance or external aggression, and in such situations, he argued, there were some broad standards to be followed where fundamental values were not breached. Later, Senior Advocate Mr. Harish Salve, appearing for an intervener, made an argument that Article 370 was a political compromise. Mr. Salve described Article 370 as an element accommodating certain political compromises within the constitutional framework. He stated that the words in the article had to be given their plain meaning and underlined that as per the words of the article, the idea was not that the President could only give effect to the recommendation of the Constituent Assembly, because had it been so, the same would have been made the precondition for the exercise of power. He also stated that the article was nothing but a political agreement which was not meant to lead to a situation which prevented integration. Mr. Salve made another argument that not applying a constitutional provision does not give individual citizens any right. He explained that instruments of accession and their interpretation had always been a matter for the sovereign, and since in the present case the accession had been complete, irrevocable and irreversible as per Articles 1 and 3, the President would have the last word on any matter concerning the accession. Mr. Salve also argued that laws cannot violate basic structure. He submitted that the basic structure doctrine was not a principle as an independent, standalone constitutional right, but a limitation inherent under Article 368 on which constitutional amendments were tested. At this point, the CJI underlined that in some judgments, the court had held that a particular law protects the basic structure, in response to which Mr. Salve submitted that when a law was made to protect civil liberties which formed a part of the basic structure, the same could be said to align with the basic structure. In context of the petitioner's argument that irreversible changes could not have been made under the President's rule, he argued that everything in one sense is irreversible. He also had examples for the same. Following Mr. Salve, Senior Advocate Rakesh Dwivedi made an argument that the view of Constituent Assembly cannot be binding. Mr. Dwivedi argued that the burden was on the petitioners to show that the view put forth by them was the correct view and that no other view could exist. He added that if there were two views, that view should be adopted which sustains the exercise of power and does not defeat the exercise of power. He also said that the character of the power of President was a constituent power and was much wider than ordinary executive power. He added that a recommendation of an inferior authority, when it goes before a superior authority, can never be binding, that too if the body was a temporary body. Finally, concluding his arguments, Mr. Dwivedi said that the decision to abrogate the article cannot be based on emotions. That's all about it. In case you want to read the full article, please go to our website, which is www.livelaw.in. and check out the top stories. We have also made a series of videos on the topic which some of you might be interested in watching. Meanwhile, if you like our content, please like and share the videos and subscribe to our YouTube channel. You can also press the bell icon to be notified. Keep supporting our channel. Thank you for watching.